is force majeure and what is little bit? Either you know or not.
Force majeure is something which is not in your control, and due to this,
in my control,
not in suppose something which is not in my control, and
mine means who's mine?
who is the executor of the contract?
So contractor only.
Yes,
And it is in control of owner?
no
So
no
tell-
one's control.
Yes.
It is no natural calamity like
Yes.
this COVID.
Okay.
In that case, we can seek some compensation and things like that.
Okay. What is frustration now? Any idea? Because you might have not
For
done
a prolonged period, when the work stops for a prolonged period for suspension of work. When there is a suspension of work for a prolonged period,
Or we can say
it is one category again, but what it is? It is one example.
State of
I'll give you a hint. I started working on the project. Now I cannot do it on time and in this cost because this is the external factors which for you are also not responsible. I am also not responsible. This is force majeure. I cannot do in the specified period and time. This is my version. Now I get another version. I cannot do this job because the principal need or principal object is no more there. A house was to be repaired in 10 days. I say I will repair in 20 days. Force majeure. I'll say that these are the reasons. I cannot repair the house because house is no more there. So when I gone to see it, it was spoiled down. But still, what I'll repair? Second case is frustration. Impossible. That is the difference. The doctrine of frustration states that frustration occurs when an unforeseen event renders performance of a contract impossible or radically different from the originally contemplated by the parties. Not there or altogether. A house you said 100 square feet, it is 5,000 square feet. I cannot do this. So the impact. No party is considered at fault if a contract is found to be frustrated. It is automatically terminated because the reason is beyond the control of both the parties. Destruction of the subject matter. You have to give power to the grid. Grid itself is not there. Frustration. Okay. There are three main elements when assessing whether frustration applies to a contract. Keep that in mind. Contract allocated the risk of the particular event occurring. It should capture that clause. Has there been a radical change in the obligations? It should not be a small change and you say frustration. No. Impact is important. Radical change due to the fault of one of the parties. Then it will not be a force majeure or frustration. It has to be beyond the control of the parties. Force majeure is just a clause, small version of that, where you are not responsible for anything and the other party is not responsible for anything and both needs to be compensated. Both. Yes. If you get, see, COVID, you cannot come to office, I cannot come to office. Let's sit amicably and whatever duration is gone, we should decide it. It will benefit them also because their deadline is also finishing the job within a particular timeline, right? Force majeure clauses are contractual clauses that restrict obligation and liabilities of parties in any agreement when a sudden, unexpected circumstances occurs which is beyond their control. This is important. All this has to be satisfied. Sudden, unexpected circumstance occurs which is beyond the control of the parties. Now a question for you and 10 minutes to think during the break.
So one question I have before this.
Okay.
In case of force majeure, if a contract is there, in case of some force measures, both the parties suffer, contractor and the owner. So who is going to pay for this force majeure losses or what the contractor made?
See, the ideal scenario is that both have to take care of their themselves. Okay, because nobody is responsible. Both after the force majeure is over, both have to sit amicably decide that let's extend this timeline to this.
This is timeline. What about
if the contractor proves that this was due to any of the fault of owner has to.
Not owner.
And if owner thinks that it is not force majeure, it is because of contractor has to bear the loss. And he will not be given any extra time. Like you propose 10 months force majeure and you could not substantiate it.
Because it happens, one example I will say, because it confused me. When you are in a previous project, COVID happens. 3 months our site was closed by the government authorities, saying that you cannot cross this border. So that site was on hold for 3 months.
Okay.
We are in Riyadh, but we cannot go to our site.
Okay.
Then we assessed some losses in 3 months what we lost, and we tried to claim to the government,
Claim what?
claim the amount money. That this much is our loss.
Are there any ground on money for that?
Yes.
Because in general, this clause talks about timeline.
Money also there.
Money never, very rare cases. In our project, that is a different topic. We will start sometime. Generally, it's an extension. Why other party will pay you when he's also suffering like you?
Yes.
It's your risk. It's your risk. If it is because of what other of one party, other party will get it from him. Very clear. But act of God. You are same risk, he is at same risk. Why he will take the heat?
Only timeline extension, and that
Generally timeline. Our case, it is cost also under certain grounds of take a risk event in our contract, which in general is not a general practice. Where the employer says, okay, I take some force majeure on me, like change in law, change in port requirements, change in custom duty requirements, because anyway, I am going to reap the benefits of this project. So this will not be force majeure, although in general this will be force majeure, but I will take this risk. So he has taken those risks.
is there any timeline to submit this claim?
In our contract, it is there, which is very unfeasible timeline. You have to submit within 5 days of a claim, 7 days, within 5 days report, and then regular
Yes,
updates.
yes. This came with us also in that project.
So you have to follow that.
They said within 7 days you have to claim.
Because why? Because first of all, understand that he has facilitated you with taking some risk. Okay, because those items in general, if he does not keep, and these are force majeure, you are supposed to know the law of country. It's your risk. He has taken that risk. Okay, now what he needs from you? Timely notification. Because if he took the risk, he need to give it to his lenders and get approval to pay you. So that is why they need on immediate basis. It will take time. And in contract, because if it is aqua contract, straight away it is written, if you do not submit within 7 days, you would lose your right. Because in our contract also it is written, same. So at one time he's supporting you, at another time he need timely notification. What it takes, 7 days, you came to know, and it don't say that when it happened. When it came to your knowledge or occurrence. Today it occurred. If it is not in your knowledge and you can prove that, your time will not start. You have to prove that it became in my custom clearance. Anything. When the decree comes, we take that day. When we receive the decree. Okay. It might have occurred, but our consultant is given. We have to give the proof. Your time start from there. So that is subject to certain condition. Now the context is, what if a contract is silent on force majeure? You will get over it.